Good morning. It is an honor and a privilege to be here. I was ashamed that I hadn't visited Nagaland all these years, and I'm 69 years old. I've visited other states of the Northeast, but not Nagaland. Though, as I was telling friends yesterday, I have been following developments in Nagaland from the time I could read and understand newspapers, which means from the age of 11. And I had occasion to interact with students from Nagaland in my days in St. Stephen's College. My wife, who's a lawyer and a mediator, visited Nagaland a few years back and came back full of stories of how she and her colleagues had learnt lessons in mediation from the Gaon Buddhas, and how they have incorporated what they have learnt in Nagaland into their mediation practice. So finally, my time has come, and what could have been a more beautiful and more moving welcome than being welcomed by a song by the hero of my life, my God, Harry Belafonte. A song which my father sang to me when I was a small boy, a song which I have taught my children, a song which my grandchildren have learnt, and today I'm welcomed by this song. I'm really overwhelmed. Now let us come to the subject which we are discussing. For me, this has been a learning process. I had not had occasion to read or study Article 371A in detail until the invitation came. My head, though, has been full, my mind has been full over the last 2-3 years with Article 370, because as a constitutional lawyer, I have been involved in the challenge to the watering down of Article 370 pertaining to Jammu and Kashmir. And when I go back to Delhi, the Supreme Court is going to take up those cases again. So I have a 370 perspective in my mind. And coming to 371, in a sense, was a logical progress. Now we all know, and another caution I want to give you, when I am offering my interpretation of 371A, I am not doing so with any sense of certitude, because in law, as in medical science, as in academics, as in theology, there is no one truth. And therefore, my attempt will be to explore, along with Mr. Jamir and along with all of you, the various facets of this article so that we can all collectively try to arrive at an understanding. Now we know that the state was created in 1962 after the 16-point agreement between the Government of India and the Naga People's Convention. And so the language of the article is substantially based on the language of the 16-point agreement. And going through the debates in Parliament of that time, I was pleasantly surprised to find that when someone raised a doubt about the inelegant phraseology of certain provisions, Pandit Jawaharlal Nehru said, let's not go into the elegance or inelegance of the phraseology. This is the language of the 16-point agreement, and this amendment is based on that. So we'd like to have as much of the 16-point agreement as possible in this article. Now, the real portion of the article which we are dealing with, and I'll do my best. We are two lawyers here. We'll both try not to be very lawyerly. We'll try not to use legal expressions. If we still slip up, please forgive us and please ask us the meaning straight away so that we clarify. Now, the main part of Article 371A, which is otherwise a long article, is 371A1. The others are what we lawyers call consequential provisions, incidental provisions, etc. Let's not spend our time on those provisions now. Let's just look at 371A1. Notwithstanding anything in this constitution, no act of parliament, please note the words no act of parliament in respect of 1. Religious or social practices of the Nagas, 2. Naga customary law and procedure, 3. Administration of civil and criminal justice involving decisions according to Naga customary law, and 4. Ownership and transfer of land and its resources shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by a resolution so decides. So, an act of parliament on these 4 subjects will not apply to Nagaland, though it would apply to other states in the country, because such acts are passed in pursuance of the power which Parliament has to pass laws on those subjects. But still, though parliamentary laws would apply on those subjects for the rest of the country, as far as Nagaland is concerned, unless the Legislative Assembly of Nagaland by a resolution says yes, these can be applicable to us. But again, I'm stressing no act of parliament. Keep that at the back of your mind, because we will soon be discussing the Constitution itself, the mother document. Individual acts of parliament may not apply, but certain overarching principles of the Constitution, I will submit, will apply, and those are going to lead to legal problems, dilemmas, conundrums as we go along. Now, this 371A is an example of asymmetrical federalism. So, our constitution is described as a federation with a strong unitary bias, that is a bias towards the center, because there are federations with a strong federal bias, where the balance is more towards the states, the federating units. But the Indian Federation is a federation with a stronger unitary bias. And in that federation, it's not symmetrical in the sense that the same doesn't apply to every state, which is as it should be to accommodate the large diversity of our country. So even at the beginning of the constitution, you had Article 370 for Jammu and Kashmir, which created a model different from that for other states because of the special situation of Jammu and Kashmir. And so now, over the years, we have gone on to go from Article 371A pertaining to Nagaland right up to 371J. So we go through so many states, Telangana, Maharashtra, etc., etc. And very recently, in the case of the capital city of Delhi, because Delhi, as many of you may know, is a very peculiar kind of a state where the state government doesn't have power over land, over police, something very peculiar. And the Supreme Court says, in the context of recent litigation relating to Delhi, that in the nature of asymmetric federalism, in the spirit of accommodating the differences and specific requirements of regions across the nation. So perhaps Delhi being the capital city, it needed a particular structure of governance which would not apply to other states. So this asymmetrical federalism in our constitution is embodied in 370 has watered down now, of course, 371 to 371J, and also the 5th and 6th schedules to the Constitution. Now, while enacting the 13th Amendment, Parliament was conscious, of course, of the special status being granted to the Nagas, and the Prime Minister, the visionary Jawaharlal Nehru, said that this is necessary for a united India which incorporates diversity, and therefore, as a requirement of diversity, Nagaland got this special status. Now, what are the first legal issues arises is whether the language of Article 371A can be read by itself as a bare bones legal text, or is the 16-point agreement to be used as an aid to the interpretation of Article 371A. And the general consensus is that the looming omnipresence of the 16-point agreement will guide or color our interpretation of Article 371A. And which is why, which my friend Mr. Jamir, Senior Advocate, will expound on separately, will throw light on whether this 371 is an enabling provision which facilitates the state of Nagaland to proactively do things for the welfare of its people, or is it merely something protective which says, center, don't come here, don't come here? Is that all to just create a kind of a stalemate, or does it enable the state to act in the interest of its people? That's something which my friend and colleague will elaborate on. But the first dilemma I want to focus on is the application of the Constitution itself. The fundamental rights, the citizens, residents of Nagaland are citizens of India, and therefore residents of Nagaland must enjoy all the fundamental rights which are available to other citizens of India. So Article 371A, which talks of no act of parliament being automatically applicable, cannot come in the way of the operation of the provisions of the mother document, the Constitution itself. And for the moment, let's just talk of fundamental rights. And therefore, let's think of the most primary fundamental rights, like the right to personal liberty, the right to equality, the right to freedom of speech and expression. Should these rights not be available in their full force to every resident of the state of Nagaland as they are to citizens of the rest of India? I don't think there can be any ambiguity in the answer. I think the answer will be yes. We are as equally entitled to fundamental rights as any other Indian. But then, now let's look at this in the context of some customary rights, in the context of gender justice. And for this, I'm going to give you two completely unrelated examples. Let's keep Nagaland out of our minds for a minute. We know that our constitution, Articles 25, 26, 29, 30, protect religious practices apart from individual freedom of religion. Now, let me remind you about the case of the famous Sabarimala temple in Kerala. So there was this particular avatar of the god Ayyappa, where in that particular hill shrine, women of menstruating age were not allowed and did not go. Because the belief was that in that particular avatar, the deity was a celibate god, and therefore women would not visit that temple. To save the Lord from temptation, to put it plainly. But public, not just public spirited, but rights conscious women said, if we have a right to worship, then we have the right to worship a God of our choice, and we can't be held back from worshipping our God because of a belief that I should not go for so and so reason. And so the Supreme Court upheld that individual's right, that individual's fundamental right. And so the Supreme Court, of course, there's controversy over the judgment. Supreme Court is looking at the judgment again, but presently the law is, the Supreme Court has declared the right of an individual woman to worship the God of her choice. Now let's go to Muslim law. Triple talaq. And we are not talking, let me explain triple talaq in a little detail, in the sense the Muslim form of divorce itself is a pronouncement of the words talaq, but over 3 cycles, over 3 menstrual cycles, so that there is scope always for repentance, for withdrawal, for reconciliation, for change of mind. The triple talaq which we are talking of here is where the husband, and it's such an abhorrent practice, there can't be any doubt about it, the husband, in a fit of rage, or because he is in such a hurry, tearing hurry to marry somebody else, in the space of 5 minutes just says talaq, 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 and that's the end of the marriage. And this so far had been protected as religious practice. But then in the triple talaq case, and now of course Parliament has passed a law after that, but it's the Supreme Court which took the lead. That was again something upholding the fundamental right of a woman. That your right to life, your right to your dignity, which is part of your right to life, can't be so arbitrarily taken away by someone just putting an end to a bond. Of course, in Muslim law, it's a contract, not a sacrament. But still, that a woman loses her rights by a quick oral pronouncement. The Supreme Court struck it down. Why I'm giving you these examples is that tomorrow, yes, no act of Parliament will touch Naga customary law or religious law. Now, as I understand it, I think this is an outsider's observation, but someone who has followed the state and its people with deep interest over the years, I think there can't be a more gender-sensitive state than the state of Nagaland and other states in the northeast. So I can't, without deeper knowledge, think of something which is so demeaning to the dignity of women in either the customary or religious law of Nagaland. But God forbid if there is such a custom, and then someone chooses to challenge that custom by reference to the fundamental rights of the Constitution, then it's going to be very difficult to say that 371A protects, because 371A doesn't protect against the Constitution and its rights. It only protects against ordinary laws of Parliament. Now come to another contemporary issue, which is the municipal elections, where, as I understand, women have traditionally not stood for elections. There is a constitutional mandate. There was the 73rd Amendment and the 74th Amendment for panchayats and municipalities. The provision for panchayats, Article 243M, specifically exempted the state of Nagaland. So as far as village panchayats is concerned, state is so clearly exempt by the Constitution itself. But when it comes to municipalities, Article 243ZC does not exempt the state of Nagaland. So reservation for women is a constitutional mandate from which the state of Nagaland is not constitutionally exempt. Now, of course, you can have a constitutional mandate of reservation, but to carry out that mandate, you need a law. So there was the state law, the Nagaland Municipal Act 2001. Now elections were not being held. People had moved the Supreme Court, and then the state of Nagaland has now repealed that law. So there is no legal framework in which women's reservation can be implemented in the state of Nagaland. But that will be for a temporary phase, because while the court normally cannot compel a state to legislate, at the same time, if there is a constitutional right, the state will have to answer the Supreme Court, because it's a pending case, that please satisfy us, please satisfy the Supreme Court that this reservation for women offends Naga customary or religious law, and that's why the state legislature doesn't want it. If that connection or nexus, as we lawyers call it, can be established, then 371A can come to the aid. But if that connection can't be established, if it's too tenuous, or the court feels that no, we can't make out any connection at all, then this reservation will have to be given effect to sometime or the other. Just two more aspects I wish to deal with. Again, a contemporary debate. on the Uniform Civil Code. Now, fortunately, apart from other communities in the country, that is, Christians as a whole, the Muslim community, there is, and I was pleasantly surprised by this, that a BJP member of parliament who heads this parliamentary committee, Mr. Sushil Kumar Modi, has himself said that this should not be made applicable to tribal states in the northeast. So, in spite of that monolithic, homogenizing mindset, there is consciousness that long accepted tribal customs should not be lightly interfered with. And while it is a constitutional mandate, it is still a directive principle, not a fundamental right of any citizen. It's not the fundamental right of a citizen to have a uniform civil code. It is only a directive principle under Article 44 of the Constitution that the state shall endeavor to have a uniform civil code. Now, uniform civil code does not necessarily mean one blanket law. It could also mean that there are laws for different communities, but all those laws broadly conform to the principles of fairness, gender equality, etc. So, Uniform Civil Code has these facets, but since a Uniform Civil Code will have to be translated into action by a law made by Parliament, then Article 371 1A will come to the aid of the state of Nagaland, because if the state of Nagaland does not adopt that act of Parliament which embodies a uniform civil code, there's no way in which it can be imposed. Then the other area is land and its resources, which is one of the 4 enumerated subjects. Now here, distinguished jurists who have given their opinions to the Government of India over the years have made it clear that no, land and its resources, whatever the Central Mines and Mineral Development Act may say, that can't apply to Nagaland. Nagaland has passed its own law. Of course, it has been reserved for the President's assent, which hasn't come. But it seems to be clear that if the Mines and Minerals Act, the Central Act, does not apply to the state of Nagaland, because the state of Nagaland has not adopted it, then it must logically follow that the state of Nagaland by itself has the power to pass a law with regard to land and minerals. Because in my understanding of the Constitution, which my friend will throw more light on, the Constitution does not, this 371A has not been enacted just to create a stalemate. It protects the state, of course, but at the same time, it doesn't mean that the state will come to a standstill. So the centre's law will not apply. Then it must logically follow that the state should be able to make a law on that subject. There can't be a vacuum. So that would be the interpretation which I would offer on this question of land and minerals. I would now want to make some concluding observations to give us a sense of perspective. I may sound like the devil's advocate, but I am wanting to be the devil's advocate only so that we have a realistic perspective. Now we are talking of constitutional protection. And it's not just 371A, but as I pointed out, it's 370, which has already been watered down. It goes on up to J. Now, what prevents Parliament in its constituent capacity? This is a legal concept, but I think it can be explained fairly simply, that when the Parliament is making an everyday law, then Parliament acts in its legislative capacity. But when the Parliament is changing the constitution, then the Parliament acts in a constituent capacity. And so every part of the constitution can be amended by Parliament as long as the requisite parliamentary majorities, and in the case of matters affecting states, the necessary majorities of 1/2 of the state legislatures. That's all that is required. Once those majorities are there, every part of the constitution can be amended, watered down, abolished. Therefore, 371A also theoretically can just go. Now take for instance, again for a moment, for a sense of detachment, let's move away from our own state of Nagaland and let's think of 371D dealing with Telangana. 371D came for Telangana at a time when the separate state of Telangana was not in existence. But from 2014 onwards, there is a new, thriving, vibrant state of Telangana. Surely, therefore, it can happen, it's not beyond the realm of possibility, that Parliament no longer feels the need for a special constitutional provision for Telangana. Now, if the constitution is amended to take away these special provisions, what is the protection which a particular state has, or the citizens or the residents of that state have? The power of Parliament to amend the constitution is subject only to one limitation which the Supreme Court has laid down itself, that is the basic structure doctrine, which means the constitution can be amended to any extent as long as it doesn't affect the basic structure of the constitution. Now, so far, there have been only 6 instances. The basic structure doctrine is 50 years old. It was laid down by the Supreme Court in 1973 in the Keshavananda Bharati case. And this year, we are, if you don't like the basic structure doctrine, then you may say you're observing the 50th year. If you love the basic structure doctrine, you will say we are celebrating the 50 years of the basic structure. There have been only 6 instances where the Supreme Court has struck down amendments to the Constitution as offending the basic structure. So it's a very, very rigorous test which the court applies. So now coming to 371A, I ask this question, let's ponder over it. Let my senior advocate colleague also ponder over it. Is 371A something so basic to the Constitution of India that the Constitution of India is unrecognizable without it. That would be the kind of test which would have to be applied. Is it such a thing where the Constitution loses its identity without its existence? Or on a larger scale, shall we say, is asymmetric federalism as embodied in Article 370, 371A to J and 5th and 6th schedules, is that asymmetric federalism a part of the basic structure of the Constitution, or is it just an important feature of the Constitution? This would be a moot legal question, and I leave you all to ponder over these questions. Thank you all for a very patient hearing.